Now, why do we insist that lawyers should write well? Why the need to write well? If lawyers do not aspire to become literary giants, why is it necessary that lawyers write well? Well, number one, to write well is to communicate well. That's, again, according to Justice Antonin Scalia, who is a great writer himself. Now we know that communication involves three elements. We have the sender, the receiver, and the message. Now, in a perfect world, communication works well if the receiver understands the message of the sender. But in an imperfect world, communication sometimes breaks down. And there are many reasons that explain why communication breaks down. But one of them is that the message itself is unclear, it's ambiguous, or not well written. So, therefore, if you want to communicate well, we have to write well. If you want our message to get across the intended audience, then we must write well. Second, language is the central tool of our trade. Now, painters or visual artists, for example, use paintbrush and other medium to create an artwork. Or dancers use their body to perform. Singers use their voice to sing. But for us lawyers, what do we primarily use in our trade? It's not the dry seal for notarization. It's not the notarial book. It's not the stamp. It's not. Rather, it is language. Language is the central tool of our trade. So if lawyers, rather, if singers, artists, and dancers take care of their voice, of their materials, of their body in order to perform or in order to produce high quality work, then lawyers must also be fastidious in using language. Third, the quality of writing can make or break a case. Now, this is true in some instance. For example, you have what you think a winning case. All the pieces of evidence tilt in your favor. But when it comes down to writing, you are not able to present it clearly, making the judge or the arbiter or whoever is the decision maker to wonder what you are really trying to say. Then there's a higher probability that you will lose the case. So that is why we need to write well, because it can largely determine whether we make or break a case. And then lastly, the law is imbued with public interest. Now, the law touches other people's lives more directly than other disciplines. I think we can get by without knowing this molecular biology, without really understanding physics, uh, without comprehending the literature on chemistry. But if we do not understand the law, there are grave consequences. That is why the law presumes that we know the law. Otherwise, ignorance of the law excuses no one from compliance therewith. Therefore, it is in the best interest of the public that lawyers write well and that legislators produce law that can be understood by the public. As Judge Learned Hand said, the language of the law must not be foreign to the ears of those who are to obey it. Because it's weird or it's strange that the law is intended for the public, and yet the public doesn't understand the law. Now, when do we consider legal writing good? What are the criteria? If a legal document achieves the writer's purpose, does that make it well written? It doesn't necessarily follow that if a legal document achieves the writer's purpose, it's already well written. It only makes the document effective, but not well written. Because by contrast, there are documents that are poorly written, but they achieve the writer's purpose. For example, if you submit a motion for consideration that is not well written, and yet the court granted the motion, it's only effective but not well written. A document or a legal document or legal writing for that matter is considered good or well written if it facilitates decision making. Now, lawyers have different types of audience. We have our fellow lawyers, we have the court, the judge, we also have clients, etc. And each of these audience has different needs and expectations. But generally, this audience read a legal document because they need to extract information which can help them make decisions or which can help them decide. So whether it's a judge reading a memorandum, a fellow lawyer reading a comment or opposition from the opposing lawyer, or a client reading a legal opinion letter from his or her lawyer, all of them have one goal. That is to extract information that can help them decide.
If you want more, make sure to subscribe so you never miss a video.